Hello, my name is Jeypraba Veerapan.
And I'm Kirutiga.
Today, we are going to advise Domio about his potential claim against Dr. Richard Maverick and Dr. Newton James. Negligence is defined by Winfield and Jolowitz as a breach of legal duty to take care which results in damage to the claimant. In negligence, for a person to be convicted of liability and damage, they have to satisfy three main criteria, which are duty of care, breach of that duty, and causation. The claimant will need to establish that the defendant owed him a duty of care and that the defendant had breached that duty of care by acting negligently. Lastly, the claimant must also prove that the damage suffered by him is indeed caused by the defendant.
For assisting the satisfaction of these criteria, over the years there have been various tests and judgments established through various cases in both the English and Malaysian law. My partner and I will be elaborating further regarding these tests and judgments and whether Domio can bring a claim against Dr. Newton James and Dr. Richard Maverick in our video.
Firstly, we will discuss whether Domio can bring a claim against Dr. Richard and Dr. Newton under the English law. And next, we will look at the Malaysian law. The first part in establishing negligence is whether there was a duty of care owed by Dr. Richard Maverick and Dr. Newton James towards Domio. A duty of care between doctors and their patients was already established in the case of Pippin and Shepherd in 1822. Therefore, there is a duty of care owed by Dr. Richard and Dr. Newton towards Domio. The second part is determining breach of that duty. We will be discussing this part separately for Dr. Richard and Dr. Newton.
Let's start off with Dr. Richard. There are two different issues that must be discussed about Dr. Richard. The first issue is about treatment and diagnosis, while the second issue is about consent. In order to prove breach of duty for treatment and diagnosis under medical negligence, two tests must be applied, which are the Bolam test and the Bolito test. Dr. Richard performed surgical thrombectomy before the full CT scan report had been finalized. In order to establish whether Dr. Richard had been negligent by not waiting for the CT scan report before proceeding with the surgical thrombectomy, the Bolam test and subsequently the Bolito test should be applied. The Bolam test was established in the case of Bolam and Free and Hospital Management in 1957. In this case, Mr. Bolam suffered a fractured pelvis during electroconvulsive therapy for his depression, and questions were raised whether there was a breach of duty as the doctor failed to restrain the plaintiff or provide any relaxant drugs. During the court proceedings, the evidence provided showed two different opinions of medical bodies, one agreeing with the use of drugs, while another argued that it shouldn't be used as there was a risk of fractures. In the end, Justice McNair established that the standard of care appropriate for doctors is the standard of the ordinary skilled man exercising and professing to have the special skill, and that the doctor should have acted in accordance with the competent body of medical opinion. However, after McNair's statement, it was ultimately established that even if the Bolam test was applied, the final say is in the hands of the court and not the medical opinion of professionals in the matter of standard of care. This was done in the case of Bolito and City and Hackney Health Authority in 1997.
Now, coming back to Domio's case, under the Bolam test, Domio must prove, on a balance of probabilities, that Dr. Richard's actions were below the required standard of care of a medical professional. If Domio could get the statement of another doctor or professional medical body that performing a surgical thrombectomy before the release of CT scan results is not an accepted medical practice, then it could be proven that Dr. Richard had been negligent under the Bolam test. A similar case that can be applied here is the case of Maynard and West Midlands Regional Health Authority. In this case, it was held that although there was a body of competent opinion which said that the consultant's decision was wrong, there was another equally competent body which supported their approach. Therefore, the courts decided that the consultants were not negligent as they had followed the practice that had been approved by a responsible body of medical opinion. This could prove to be disadvantageous to Domio's claim, and that's where the Bolito test, which was established in the case of Bolito and City and Hackney Health Authority, comes in. Under this test, the court should not accept a defense argument as being reasonable, respectable, or responsible without first assessing whether such opinion is susceptible to logical analysis. Even if Dr. Richard manages to get a professional opinion that his actions were on par with other medical professionals, Domio still has a chance of establishing breach of duty if the courts find Dr. Richard's argument to be illogical.
However, one factor that must be taken into account in this case is utility of conduct. If it is possible to show justification in taking the risk in question, the defendant can escape liability. An example of a case which applied utility of conduct is Ward and Hertfordshire County Council. In this case, the courts held that there was no negligence because the situation involved was an emergency and justified the risk taken by the defendant. In Domio's case, Dr. Richard could justify his actions of conducting the surgical thrombectomy without waiting for the results of the CT scan because Domio's life was in danger. Therefore, Dr. Richard would not be held liable for conducting the surgical procedure without waiting for the results of the CT scan. As such, breach of duty by Dr. Richard could not be established for the first issue.
Regarding the second issue, which is about consent, Dr. Richard had failed to advise Domio about the 5% risk that comes with surgical thrombectomy. For issues regarding informed consent, the Montgomery test, which was established in the case of Montgomery and Lanarkshire Health Board, should be used in order to establish breach of duty. In the case of Montgomery and Lanarkshire Health Board, the Supreme Court replaced the Bolam test for consent with a test where the materiality of risk involved had to be assessed by reference not to a responsible body of medical opinion, but by reference to a reasonable person in the patient's position. Doctors, as a result, are now obliged to ensure reasonable care to make sure that the patient is aware of any material risk involved in any recommended treatment and of any reasonable alternative or variant treatment. By not advising Domio of the risk involved in the surgical procedure, Dr. Richard had breached his duty of care.
Now, let's discuss whether there had been a breach of duty by Dr. Newton. This can be determined through the Bolam test as well. Generally, a member of a particular profession is said to discharge their duty by conforming to the standards of a reasonably competent member of that particular profession, and inexperience is no excuse. In this case, an experienced doctor would suffice. For Domio's case, we can refer to the application of Bolam in terms of consent in the case of Sidaway and Governors of the Bethlehem Royal and Maudsley Hospital 1985. Where it was held that the defendant was not liable because the surgeon had followed the approved practice of neurosurgeons in not disclosing the risk of spinal cord damage. Therefore, with reference to this case, Domio would not be able to bring a claim against Dr. Newton for breach of duty, as there is considered no negligence. However, Sidaway and Governors is a debatable and criticized case, as there were some dissenting arguments regarding the decision upheld. One such was by Lord Scarman, who stated that Bolam should not be applied in the case of informed risks, and doctors should inform patients of potential risks that they might face. He also stated that the court should be deciding whether there was a breach of duty and not the medical body opinions. This related to the need for application of Bolito, where authority of decisions is emphasized solely under the court for breach of duty, and even if there was medical opinion sought, then ultimately it should be logical in the sense to be applied to the circumstances of the case. If Dr. Newton is able to conjure a body of medical opinion that other doctors would also advise the spinal fusion surgery for Domio's condition, then he would not be held liable. However, the court's role in determining whether Dr. Newton had breached his duty of care or not would ultimately be the final say in the case of liability with respect to the application of bolito.
The third part in proving negligence is whether causation can be established. In order to establish causation, two aspects must be looked at, which are causation in fact and causation in law. The test for causation in fact is the but-for test, which was established in the case of Cobb and Kirby McLean Limited. According to this test, the claimant is required to prove on a balance of probabilities that there is a necessary connection between the defendant's breach of duty and the harm that is suffered by the plaintiff. For the second issue, in order to establish causation in fact, the case of Chester and Afshar can be referred to. In this case, the High Court held that although the defendant had not been negligent in his surgical performance, he was still liable as he did not inform the claimant about the risk involved, and the claimant might not have suffered injury if the surgery was performed on another day. The defendant appealed to the Court of Appeal, but the appeal was dismissed on the ground that the defendant had failed in his tortious professional duty, which satisfied the but-for test, and that the claimant deserved a remedy. Therefore, for the second issue regarding Dr. Richard, causation in fact can be established.
Depending on whether Domio is able to prove that Dr. Newton had breached the standard of care, we are able to move on to causation. For causation in fact pertaining to Dr. Newton's issue, we will need to again apply the but-for test. As such, we need to analyze whether Domio would be able to provide proof that the spinal damage would not have occurred but for the act of negligence by Dr. Newton during the operation. This can only be established if Domio would be able to get a medical body's opinion that the spinal injury is not a risk of the operation procedure and was due to some act of negligence or omission performed by Dr. Newton during the surgery.
Next, the court must proceed to establish causation in law. Causation in law, which is also known as remoteness of damage, can be proved by using the foreseeability test, which was established in the case of Wagon Mount No. 1. Under this test, the defendant could be held liable if the type of damage caused is foreseeable. The kind of damage must be reasonably foreseeable, although the extent of the damage or the precise manner of its occurrence need not be reasonably foreseeable. In order to recover for damages from Dr. Richard, Domio must prove that the pulmonary embolism he suffered from is foreseeable. It is reasonably foreseeable that Domio would suffer from pulmonary embolism because it is a known fact that surgical thrombectomy has a 5% risk of death by embolism. With this, causation in law can also be successfully established against Dr. Richard.
Similarly, after looking under causation in fact for Dr. Newton, we would proceed on to causation in law. For causation in law, again, under remoteness of damage, we need to establish whether the spine damage suffered by Domio was reasonably foreseeable. Here, we make reference to the case of Bradford and Robinson's Rentals 1967, where the claimant suffered frostbite from travelling long distance in the employer's van, which had no working heater. The court held that it was reasonably foreseeable that this action would bring about some form of cold-related disease, and it did not matter that the specific damage was frostbite. Thus, the defendant was held liable. If Domio is able to garner medical advice and facts from professionals that there were no chances of damage to the spine through the surgery performed, then Dr. Newton can be held liable for being the cause of damage, as only his negligence during the operation was the cause of the spinal injury.
In essence, Domio could not file a successful claim against Dr. Richard for negligence regarding treatment and diagnosis because Dr. Richard's action could be justified. However, Domio could make a successful claim regarding consent because doctors have an obligation towards their patients to disclose material risk of surgical procedures. In regards to Dr. Newton, Domio does not have a potential claim for negligence under the English law as we are unable to prove that there had been a breach of duty in the first place.
Similar to the English law, if this case is to be tried in the Malaysian courts, the first thing that should be considered is whether there is a duty of care owed by Dr. Richard and Dr. Newton towards Domio. As previously mentioned, duty of care by doctors towards their patients was already established in the case of Pippin and Shepherd.
As there is a duty of care, the next thing to consider is whether Dr. Richard had breached that duty of care. In order to establish breach of duty by doctors, Malaysia initially used the Bolam test as well. The first Malaysian case to apply the Bolam test is the case of Chin Kiao and Government of Malaysia and another in 1967. Here, the Privy Council overturned a federal court's decision and by quoting the Bolam test, found that the doctor was negligent when an ama gave penicillin injection at a clinic. The Malaysian courts then departed from the Bolam test in the case of Fu Fiona and Dr. Su Fok Moon by applying the case of Rogers and Whittaker. In the case of Rogers and Whittaker, the courts held that the court will adjudicate on what is the appropriate standard of care after giving weight to the paramount consideration that a person is entitled to make his own decision about his life, and doctors must warn patients of the material risk of the proposed procedure. For quite some time, there was confusion on whether the Malaysian courts has fully departed from the Bolam test and applied Rogers and Whittaker for both disclosure of risk as well as diagnosis and treatment. The issue was clarified by the Federal Court in 2017 in the case of Zul Hasnima binti Hassan Basri and another and Dr. Kupo Velamani P and others. Here, the court held that in deciding whether there was negligence, the applicable test would be the Bolam test, as the issues raised were related to diagnosis and treatment. This means that the medical practitioner has a say as to whether there was negligence, and this test is used together with the Bolito addendum.
As the Bolam test would be applicable in Malaysia, breach of duty by Dr. Richard could be established if Domio could prove that a professional medical body would not have proceeded with the surgical thrombectomy before the CT scan results were out. However, the defense of utility of conduct could also be raised in Malaysian courts. Utility of conduct was considered in the case of Mahmud and Government of Malaysia and Anor in 1974, where the plaintiff claimed that a police officer unlawfully and negligently shot him. It was held that the shots fired by the police officer towards the plaintiff was justified in order to prevent the plaintiff from escaping. In Domio's case, Dr. Richard's action of not waiting for the CT scan results before conducting the surgery could be justified because Domio's life was in danger.
In addition to performing surgery before the CT scan results were out, Dr. Richard also did not advise Domio about the material risk of the procedure. A recent 2013 Malaysian case regarding consent that applied the principles in Rogers and Whittaker is the case of Norizan binti Abdul Rahman and Dr. Arthur Samuel. In this case, the plaintiff, upon finding herself pregnant with a fifth child, requested the defendant, an obstetrician and gynecologist, to terminate her pregnancy and at the same time insert an intrauterine contraceptive device. The defendant assured the plaintiff that it is a simple procedure and did not warn her about the risk involved. While the procedures were being performed, the plaintiff's right uterine wall and right artery of the uterus were perforated and required an emergency life-saving operation by the defendant to remove her womb and right ovary. The court held that the defendant was in breach of his duty to advise, and as a result of the breach, the plaintiff has suffered damages as claimed. Although the courts of Malaysia apply the case of Rogers and Whittaker instead of the Montgomery test when it comes to informed consent, the basic principle that doctors must inform their patient of the material risk involved in a medical procedure is still the same. Therefore, a breach of duty by Dr. Richard for the issue of consent could also be established under the Malaysian law.
For Dr. Newton, he would be judged against other doctors who possess the same skill in order to determine whether he had breached his duty of care. All characteristics of Dr. Newton need to be taken into account, from his qualification and background to the level of experience he has in the specialized field. For Domio's situation, we would like to look at the case of Chen Tam Kong and Excellent Strategy Sdn Bhd 2009, where the defendants had failed to diagnose a rare type of disease to the spine, which is similar to a common stroke, and failed to take proper care to the plaintiff's spinal cord during his treatment of physiotherapy due to pain in his lower back. The High Court dismissed the plaintiff's claim as they made reference to the Rogers and Whittaker, which was applied in Fu Fiona and Dr. Su Fok Moon and Anor 2007. Through logical analysis with the advice of medical professionals specializing in spinal cords, neurology and stroke, the cervical epidural abscess was considered a very rare infection that defies early diagnosis and treatment. After evaluation with scrutiny, the court established that the defendants did act according to the appropriate standard of care expected by them as specialists. If Domio is unable to prove that Dr. Newton has breached the standard of care by not diagnosing properly his condition that subsequently led to his spinal damage after the surgery, which was not on par with others in his professional field, then Domio would not be able to bring a claim against Dr. Newton for negligence.
Lastly, in order to prove negligence, there must be causation. Causation is often a problem for the plaintiff in medical negligence cases. The plaintiff could solve the first issue of establishing liability if he can find an expert who will testify that some aspect of the care afforded to the patient was of a lower standard than expected. However, the defendants will often argue that the negligent act is irrelevant to the injuries for which compensation is sought. For causation in fact, the Malaysian courts also use the but-for test to decide whether the damage would not have occurred but for the defendant's negligence. Here, the case of Chester and Afshar could also be applied under the Malaysian law. Therefore, causation in fact can be established for Dr. Richard. Next, the foreseeability test would be used to determine causation in law. As it is reasonably foreseeable that Domio would suffer from pulmonary embolism, causation in law could also be established for Dr. Richard.
Dr. Newton's issue under causation also follows the similar prospect as the English law. However, do take note that this is a potential scenario subject to Domio already establishing a breach of duty by Dr. Newton. Under the but-for test for causation in fact, we are making reference to the case of Swami and Matthews and Anor, 1968, where there were allegations raised that an injection of 5 cc estilarsen for an itch on the plaintiff's hands and legs had caused a paralysis to those particular areas. Here, the court held that the defendants were not liable as the plaintiff failed to prove that the injection had caused the paralysis suffered. Applying this to Domio's case, Dr. Newton can only be held liable if Domio is able to adequately prove before the court that the surgical procedure done by Dr. Newton led to the spinal injury suffered. Failure to do so would result in the claim failing before the jury. As for causation in law, the foreseeability test can also be applied depending on the facts pertaining to the surgery performed and procedures undertaken. Ultimately, though, since earlier we had not been able to establish breach of duty in the first place for Dr. Newton, there is no need to proceed on with causation, as Dr. Newton cannot be held liable for the injuries sustained. Therefore, in Malaysia, Dr. Richard could not be held liable for conducting the surgery before the CT scan results were out. He could, however, make a successful claim against Dr. Richard for not disclosing the 5% risk that comes with the surgical procedure. Other than that, Dr. Newton could not be held liable for negligence because he had not breached his duty of care.